welcome to the government of the Philippines. Sir, please introduce yourself, Mr. Ambassador, and I will provide the spelling of the ambassador's name. Thank you. Maybe not that
high. Ms. Susan Wilson, Chair of the Special 301 Committee, distinguished members of this committee, I am Jose Cuisia Jr., Ambassador of the Philippines to the United States of America, and I am with our commercial counselor, Ms. Maria Alvero, or Nini for short. On behalf of the government of the Philippines, may I express my appreciation for the opportunity to appear before this committee and to convey the Philippine request to be removed from the watch list of the 2014 Special 301 report. The endeavor to earn a way out of the watch list has been a long one, beginning from the time the Philippines succeeded in getting itself removed from the priority watch list in 2005. It required responding to the concerns raised by stakeholders and the evolving challenges in IPR enforcement, and took the specific form of resolutely working for the passage of necessary legislation, establishment of institutional infrastructures, and the intensification of enforcement operations to create an IP regime that in fact provides adequate and effective protection of intellectual property rights. These efforts have not gone unrecognized by the world, but not yet by the United States, I regret to say. The Philippines is recognized by the Association of Southeast Asian Nations as the champion on IPR enforcement among the members of ASEAN. European IP enforcement experts have also recognized the progress and development of the IP regime in the Philippines. No less than the Director General of the World Intellectual Property Office has cited the IP office in the Philippines to be one of the model offices in the region for being extremely dynamic. Finally, the 2013 Intellectual Property Rights Index, or IPRI, released by the Property Rights Alliance, ranked the Philippines #2 out of 18 in patent protection in the Asia and Oceania region, and #25 out of 130 in the world. The crux of the case for the removal of the Philippines from the watch list may be simply stated. The Philippines has substantially addressed all the U.S. concerns raised in the Special 301 report of 2013. These concerns, expressed in the form of actions that they call for, are the following. 1. Adoption of implementing regulations that will further strengthen and clarify Republic Act number 10372, which amends and updates the Philippine copyright law. 2. Taking important steps to address piracy over the internet, in particular with respect to notorious online markets. 3. Strengthening criminal enforcement of IPR. Improving predictability with respect to search and seizure orders. 5. Amendments to the patent law that limit the patentability of certain chemical forms unless the applicant demonstrates increased efficacy. And 6. Protection against unfair commercial use and unauthorized disclosure of undisclosed tests or other data generated to obtaining marketing approval for pharmaceutical and agricultural chemical products. All of these actions have been taken. Our submission details the actions taken and identify which measures addressed which concern. Allow me to highlight the efforts taken by the Philippines through the Intellectual Property Office and the National Committee on Intellectual Property Rights in addressing the concerns of the U.S. government over the protection of IPR in general and in addressing the specific concerns as laid down in the 2013 Special 301 report. In February 2013, Republic Act number 10372, which amended and updated the Philippine copyright law, was signed into law. Some of the groundbreaking provisions in the law are the grant of enforcement and visitorial powers to the Intellectual Property Office of the Philippines, or IPOPHIL, the introduction of secondary liability in copyright infringement, legal remedies for the circumvention of technology protection measures, or TPMs, and rights management information, or RMI, accreditation of collective management organizations, and the creation of the Bureau of Copyright. In less than a year after its signing, the government completed all the rules and regulations necessary for the implementation of this new law. IPOPHIL is now empowered to conduct physical piracy visits to establishments violating IPR and to conduct investigations relating to online infringements, as well as issue warning or compliance notices to Internet Service Providers, or ISPs. The provision on secondary liability reinforces copyright liability by also making liable those who facilitate, induce, or contribute to the commission of copyright infringement under certain conditions. Recently, the IPOPHIL was able to take down one of the notorious internet sites, cat.ph, or Kick-Ass Torrents, by issuing a 72-hour temporary restraining order, TRO, and later on expanding it to 20 days, prompting the owners of the cat.ph to switch to another domain. Legal remedies against circumvention of technological protection measures and alteration or removal of rights management information has likewise been incorporated in the new law, in compliance with the country's obligation under the WIPO Internet Treaties. As this remains an issue of the USTR, the Philippines will also study and evaluate the need to come up with a legislative measure that will treat mere circumvention of TPM and RMI as a separate offense. In addition to Republic Act No. 10372, 3 more IP-related laws were signed in 2013. Combined, all these measures help in setting the stage ready for the Philippines to introduce a more holistic approach to IP protection and development. These are RA number 10515, or the Anti-Cable Television and Cable Internet Act, that penalizes the unauthorized access to cable TV and cable internet. The second one is RA number 10557, or the Philippine Design Competitiveness Act of 2013, that seeks to promote and strengthen the protection for design. And last but not least is RA number 10365, or the amendment to the Anti-Money Laundering Act of 2001, that includes IP code violation as an unlawful activity or predicate offense in the crime of anti-money laundering offenses. To complement the legislative reforms, the Philippines established programs and other collaborative efforts with other agencies geared towards a cohesive and holistic approach to IPR protection and enforcement. These programs and collaborative efforts include the following. Based on IPOPHIL's institutional arrangement with the Bureau of Internal Revenue, or BIR, the IP violators will now be subjected to tax investigation and filing of possible tax evasion cases. 2. The IPOPHIL promulgated in 2012 its examination guidelines for pharmaceutical patent applications involving known substances to guide patent examiners in evaluating patent applications given the provisions of the Universally Accessible Cheaper Quality Medicines Act. These guidelines clarify standing concerns on patentability. The Supreme Court promulgated the rules of procedure for IP cases that govern civil and criminal actions for IP violations lodged before the regional trial courts, which are designated as special commercial courts. IPOPHIL regularly conducts training for justices, designated commercial court judges, court personnel, and prosecutors on IP cases. In the Department of Justice, the investigation of IPR cases has recorded a high disposable rate of 83.67%. From 2011 to 2013, IPOPHIL already obtained 6 reported convictions of IP crimes, a good improvement compared to the past year's records, showing that the implemented reforms, supplemented with the continuous capacity building seminars for judges and prosecutors, and complemented by the proactive stance of rights holders to prosecute IP cases, are working. IPOPHIL established a mediation and arbitration office in 2011 with rules that are consistent with the WIPO arbitration rules and in partnership with the Philippine Dispute Resolution Center, or PDRC. This has made IPOPHIL the first country in Asia to provide two mechanisms for alternative dispute resolution, ADR, and mediation and arbitration. The ADR, IPOPHIL has a record of 44% success rate for this year. IPOPHIL has made available a warehouse facility which can be used by right holders for free to store seized goods during the pendency of IPR violation cases. IPOPHIL sealed an institutional arrangement with the Department of Justice to provide full-time prosecutors for the handling of IPR violation cases, with the Optical Media Board for certain IPOPHIL personnel to be deputized as OMB agents, with the Bureau of Customs to allow the grant of mission orders for IPOPHIL to conduct visitorial and inspection powers on imported items in violation of the IP Code and the Tariff and Customs Codes of the Philippines.
Mr.
And an
Ambassador,
institute.
we're at 10 minutes.
I'm sorry.
We're at 10 minutes.
Okay, I'll be short.
Absolutely.
Done. And an institute arrangement, National Telecommunication Commission, to address piracy on the internet. I have some others which I will not read anymore. All these measures taken in response to concerns stated in 2013 Special 301 report, on top of the measures taken earlier in accordance with the suggested focus area, or have succeeded in establishing an IP regime in the Philippines that may be said to provide adequate and effective protection of intellectual property rights. We make no claim to perfection, as I am sure you make no demand for perfection. What we claim to have achieved is an IP regime that has demonstrated the capacity to improve, and that may be reasonably be expected to keep improving in the foreseeable future. Your intellectual property right holders may still have, I'm sure, more concerns that they want to be addressed. Let us together join to assure them that those concerns are more likely to be addressed when the great effort mounted in recent years by the men and women in many Philippine agencies working together to improve the IP regime in the Philippines is given the recognition that they deserve. Thank you.
Mr. Ambassador, thank you very much for your comments today, and thank you to the government of the Philippines for the outstanding efforts that you've undertaken over the past few years, and for all of the successes that you've had. We look forward to continued dialogue with you. Thank you for the invitation to work with stakeholders. Please know that we will give full and fair consideration to all of the information that you provided and to the status of the Philippines in this year's review. My colleagues had several questions for you today. We will provide those in writing after the hearing, and would very much appreciate answers to those questions. And of course, we will continue our very collaborative and cooperative dialogue. So thank you very much for joining us.
Thank you very much to Madam Chair and to all the members of the committee. Thank you.
Thank you. Now I would like to invite the government of Ukraine to take the table, please. Welcome. Thank you for joining us today. Please state and spell your names.
Thank you for the invitation. My name is Mykola Kovinya, M-Y-K-O-L-A, K-O-V-I-N-Y. I am chairman of the State Intellectual Property Service of Ukraine.
My name is Ihor Baranetsky, H-O-R-B-A-R-A-N-E-T-S-K-Y, head of economic department of the Ministry of Ukraine.
As a priority foreign country, I suppose you will have a lot of questions for me, and it's the reason why I go through briefly determining the authorized collective management society by the State Intellectual Property Service of Ukraine. It's a first question according to a report of International Intellectual Property Alliance. It's true that procedure for determining the authorized collective management society which will collect and distribute a royalty for the use of phonograms and videograms published with a commercial purpose was approved by the order of the Ministry of Education and Science, which according to the decision of the Higher Administrative Court of Ukraine from October 17, 2012, it was declared that as not compliant with the legal acts that take procedure over the order and invalid. In view of revocation of this order, a legal vacuum came up in the sphere of collective management that led to the conflict of interest in relations between authors, performers, producers, other copyrights and related rights subject and collective management society. The State Intellectual Property Service of Ukraine tried to resolve this conflict through preparing new order with the different rules, but in October 16, 2013, the Circuit Administrative Court of City of Kyiv made decisions to cancel this order as well. Representative of European Union Commissions and Economic Department of the United States Embassy in Ukraine also has been as a part of this court procedure. Of course, the CIPSU filed an appeal against the court decision in January 25th of this year, and we hope we will cancel this decision. Anyway, with proposal of reforming the system of collective management of priority rights of copyrights and related rights subjects, provision of illegal activities of collective management societies, as well as improvement of legislative base in sphere of collective management, the CIPSU has developed a proposal to the draft law on collective management of property rights, of copyrights and related rights. Another act of the CIPSU is follow. We tried to improve our management system in Ukraine through the state organization, Ukrainian Agency of Copyright and Related Rights, which is under sphere of the CIPSU's management. We try to use as a tool for to get in order our collective management system. Just briefly, a few words. In 2013, according to statistics, all 15 collective management societies are registered in Ukraine, collected royalties, about 65 million hryvnia, and state organization collect half of this amount. And of course, such acts shows much more effective situation in Ukraine this year, and such steps of the CIPSU also shown in the report of Alliance. Our situation in copyright and related rights enforcement in Internet. I should tell you that we have fourth edition of this draft law, because we try to find some compromise between rights of how to say rights of copyright society and parties which is we call service providers. Now we are starting to 5th edition, which will be published, I hope, in 1 week. And about our activities of the state inspectors of intellectual property, during the 2013, our inspectors held 400 inspections and 265 joint inspections with the General Prosecutor Office. As a result, we have about 300 administrative offense reports. We drawn up more than 900 exemplars of counterfeit products. Total amount more than 2 million hryvnias. According to information from Ministry of Internal Affairs, we have more than 500 criminal cases. Our Ministry of Internal Affairs provide a special operation which give us half of announced criminal cases only in this operation. During last year, we closed 20 sites, but in spite of the state activities, some of sites are still available since they transferred the servers with illegal content to the hosting platform beyond the Ukraine territory, which is not so good for Ukraine. And according to our state judicial administration of Ukraine, in 2012, 262 persons were convicted for crime with real terms violation. Our enforcement of intellectual property rights on the border, our Department of Customs Affairs reports about 2,000 cases during custom clearance suspensions, and also decision on administrative sanction for goods about 100,000 Ukrainian hryvnias. Actually, I would like to finalize my speech. I think Ukraine has some progress in IP protection, and I'm ready for your question. Thank you.
Thank you very much for your testimony. You mentioned that both today and in your written testimony, the allocation of budget resources for the legitimization of the government use of software, and that you've done inspections and you've identified many instances in which there is unlicensed software on government computer systems. Can you please briefly describe for us what your plans are going forward now that you've made these identifications? What are the plans of the government to address this, and from both a budgetary standpoint and a practical standpoint?
Yes, thank you for your question. The CIPSU has provided the Ministry of Finance of Ukraine with a relevant proposal to the amount of 500 million UA hryvnia which is necessary for legalization in 2014, but the law of Ukraine on the state budget of Ukraine for 2014 does not provide these funds for legalization. In view of this, the amendments have been developed to the mentioned law in order to ensure the state financing of legalization procedure. The SIPSO also development the draft of special acts to optimize information which is necessary for legalization procedure. I hope in new parliament after Ukrainian revolution we will revise our law, our state budget, and we hope to continue the legalization procedure with amount at least 250 Ukrainian hryvnias in 2014.
Thank you very much for your response. We find ourselves at the 10-minute mark, so we did have some additional questions, so we would like to pass those to you in writing after the hearing, and you'll have 2 weeks to respond. Yes, please.
Maybe one small remark. So the IPR enforcement issues was and will remain the priority issue for the new government. It will be formed very soon, so probably this week. And moreover, it's not only priority for Ukraine. As far as this year, we are going to sign the association agreement with EU that will include deep and comprehensive trade agreement. It will be additional impetus to enforce and to protect IPR in Ukraine. So we do hope, moreover, we're sure that Ukraine will do even better progress in this sphere this year. Thank you.
Thank you very much for that. We very much look forward
Also,
to
we
it.
hope our parliament will be much more active than last year.
Thank you. And we'll definitely be in touch after the hearing. Thank you again for coming today. So we'll take a 10-minute recess and